Hello and welcome to the HRHuddle on redundancies in the context of COVID-19 with Employment Solicitor Keeley Baigent of KSAB Law. Understandably, today's session has been extremely popular and we've had a lot of questions sent in which we'll endeavour to answer. If you do have any additional questions, please put them in the chat box, and if we can't get through them today live, we will answer them and come back to you. Today's session will probably be about an hour and a half. If we do run over and you need to leave, don't worry. I'm recording the session and it'll be sent to you along with Keeley's slides. So welcome, Keeley, and thank you for joining us again with your ongoing support and advice to the HR members in these challenging times. So I'm going to pass over to you to talk about everything redundancies.
Okay, so hello everyone, and welcome to today's session. I can't actually see you, but I know you're there, out there. So as we know then, the government announced the end of the coronavirus job retention scheme, and this is going to end on the 31st of October. Also from the 1st of August, employers will be required to pay a contribution towards the furlough pay of their employees on furlough. And so we're looking at increased costs really for employers from the 1st of August. The contributions that they are required to make are in August. Employers are going to be required to pay employer national insurance contributions and also employer pension contributions towards the furlough pay. They're also in September going to be required to pay 10% of employees' 80% of furlough pay, and recoverable furlough pay will be capped at £2,187.50. From October to the end of that month, employers will be required to pay 20% of employees' 80% furlough pay, and that will be subject to a cap of £1,875. So as a result of that impending end date, and because of the financial contributions that employers are going to have to make from the 1st of August, these are the reasons why employers are now considering whether or not they need to make redundancies. Dealing with redundancies is obviously quite daunting for employers and those who are going to be conducting the process. There's always that nature of unpredictability because we don't know how employees are going to react and we don't know what issues employees are going to raise during the process. Employers are faced with the prospect of becoming too lean when work picks up and having to weigh that up against cutting essential costs now. So it's difficult for everybody. Saying that if employers are going to need to consider making redundancies, it is essential that they look at the procedure that they need to adopt in making fair redundancies in order to avoid unfair dismissal claims. So I'm going to move on then and move to my first slide to look at what the factual circumstances need to be present in order for a redundancy situation to arise. So I will share my screen. So the first thing we're going to have a look at is what factual circumstances need to be present for there to be a redundancy situation. So the statutory definition then of redundancy identifies 3 sets of circumstances: a business closure, a workplace closure, or diminished or reduced requirements of the business for employees to do work of a particular kind. So broadly speaking, redundancy is used to describe a situation in which an employer decides to reduce the number of its employees, either within the whole business or within different sites. Now, this might be for a number of reasons. It might be because of economic pressures, it might be because of technological developments, or it might be because of an internal reorganisation. In today's world and today's circumstances, we're going to be predominantly looking at the implications of the government's guidance to deal with COVID-19, and that's resulted obviously in economic pressures for businesses and reduction in work. So those really are going to be the reasons that we're looking at making redundancies at the present time. So where does collective consultation come in? So there's a bit of a misunderstanding, I'd say, generally on the street about when do we need to collectively consult. And I'm getting questions that, oh, hold on, we've got to go through a redundancy consultation process lasting 30 days or 45 days, haven't we? Well, the answer to that is no, not unless you're making 20 or more, or proposing to make redundant 20 or more employees at one establishment redundant in a period of 90 days or less. So if you are looking at making redundancies of less than 20 employees, then collective consultation doesn't apply. If you are looking at making 20 or more employees redundant in a period of 90 days or less, then it does apply. If it applies, then your obligation is to inform and consult with appropriate representatives of the affected employees. And that consultation period must last for 30 days before the first dismissal, if you're looking at making 20 to 100 employees redundant, or for 45 days if you're making or proposing to make 100 or over employees redundant. So that is where collective consultation applies. Who are appropriate representatives? Appropriate representatives are trade union representatives if you recognise a trade union. If you don't recognise a trade union, then it's either an elected body of employees who are elected by the affected employees, or alternatively a standing body of employee representatives who have the authority to represent the affected employees in the workplace. So most employers are going to need to elect employee representatives, I would say, as I say, unless they've got a standing body or they recognise a trade union. There's quite complicated rules about electing employee representatives that I'm not going to go through today, because I understand that most of you are looking at making potentially less than 20 employees redundant. But if you do need assistance on that, just obviously let me know. Okay, so secondly then, if an employer is proposing to make 20 or more people redundant in 90 days or less, then they need to notify the Secretary of State using a form called an HR1 form. And the notification periods are the same as the consultation periods. If you fail to collectively consult in the way prescribed by the legislation, then you are exposing yourselves to a protected award claim, the amount of which is 90 days pay in respect of each employee. So it's quite a substantial award. So it's something that needs to be followed and complied with if this applies to your business. We're just going to have a look then at a couple of questions that have been received about collective consultation. So I think Eloise is going to read those and I will answer them. So I'm going to just stop my sharing now.
Great stuff, thanks Keeley. So one of the questions is, what's the best way to ensure that all affected employees in a collective redundancy process have access to an appropriate representative, that the consultation is effective, given that a lot of employees may not be in the workplace at the moment?
Yeah, and it's an interesting question. I think the main thing is we've got to accept that these processes are potentially going to take longer and be more difficult in the present climate, particularly because of employees working from home if they can, or being on furlough. Appropriate representatives, in my view, need to be taken off furlough. So once they are in place and once they've been elected, if that's the process an employer has to go through, then they need to be taken off furlough, because in order for them to properly conduct their roles as appropriate representatives, then they're going to be working and they're going to be working particularly hard, because they're going to have to discuss, consult and with both the affected employees that they represent, but also with the management as well. So they're going to need that time to do that, and they need to be off furlough to do it, in my view. And we need to make sure that all employees have got the appropriate equipment, IT equipment, to be able to discuss with their elected employee representatives and management where appropriate, to properly be able to be consulted with. So that's if they haven't got laptops, if they haven't got computers, we need to make sure that if we can, they're provided, or we bring them in for meetings, and we make accessible locations for them to have meetings with their appropriate representatives. But of course, we have to make sure we've got appropriate health and safety requirements in place, social distancing and everything else to be able to do that. And that falls on the employer to do. So yeah, we have to accept it's going to be more difficult, more intricate. We need to make sure that the employees have got the appropriate mediums to properly be consulted with, and we bring the appropriate employees, appropriate representatives off furlough.
Great, thank you. So can we rely on the special circumstances defence to shorten the time that we should spend on collective consultation?
Yeah, so this is a defence. So if an employer fails to comply with those periods of consultation, as I say, employees can bring, or their representatives can bring, that protected award claim. There is a defence to failing to follow that required period of consultation, and that's if those special circumstances apply that prevent the employer from complying with that duty. It's special circumstances. The threshold is quite high, and therefore, although it's arguable, even in insolvency situations, it's difficult. So the threshold is high, but yes, there is a special circumstances defence that could apply. Even if the special circumstances defence does apply, the employer still has to do something. It can't just sit there and say, special circumstances, I'm not complying. It has to do what it can. So it has to be able to show that it's taken reasonable steps to comply with at least some of the obligations, or all of the obligations, to the extent it can at that relevant time.
Right, great, thank you. Thanks, Keeley. So moving away from collective consultation, because I know majority of the people online, it's not relevant to, but I know you've said you're happily to speak to people directly. Moving on to some other questions we've had. Why is it important to follow a fair procedure in making an employee redundant?
Okay, so we touched upon this at the start. If an employee has got 2 years service or more, and we fail to follow a fair procedure in dismissing them by reason of redundancy, they can bring a claim against us in the Employment Tribunal for unfair dismissal. So it's all about the procedure. Obviously, we've got to have the reason there that, you know, we can't just say it's a redundancy situation when it isn't. It has to be a true redundancy situation. And then we have to follow a fair procedure in dismissing that employee for redundant. And we have to be fair in dealing with that process, that employee. And I'll go through the procedure, as I say, later on in the discussion.
Great. But what if an employee doesn't have 2 years service or more? As employers, do we still need to follow a fair procedure in respect of that employee?
So arguably not, because if an employee has got less than 2 years service, then they can't bring an ordinary unfair dismissal claim against us. However, we do have to exercise some caution, because if they have got less than 2 years service, they can still bring a claim against us for discrimination if if they feel they've been discriminated against.
Mm-hmm.
And they can still bring a claim for automatic unfair dismissal if they believe that their dismissal actually wasn't on the ground of redundancy. It was for, say, some other automatically unfair reason. And in that regard, there's a list of automatically unfair reasons in the legislation. For example, dismissals relating to health and safety, or dismissals for the employee asserting a statutory right. So if the employee believes that their dismissal actually isn't relating to redundancy, and they believe it's for one of the automatically unfair reasons, then they can bring a claim against us on that basis. With regard to discrimination, if they believe that they have been selected or dismissed because of a discriminatory reason, then again, we're exposing ourselves to a potential discrimination claim. So although a full procedure may not be followed in respect of these individuals, it might be that we want to at least go through some selection process, for example. So if we are needing to select a number of employees from a group of employees to be dismissed by reason of redundancy, then we don't just go to the person who works part-time or that has had a lot of time off because of, say, a disability-related reason. We apply an objective selection criteria to that pool, and we select the employee with the lowest score, or employees with the lowest score, depending on how many we need to make redundant, to be at risk of redundancy. So it might be that we just do the selection part of the process, the objective selection part of the process, rather than the full consultation part of the process. So I would say, obviously it depends on the relevant circumstances, and yes, you're not going to be exposed to an ordinary unfair dismissal claim, but just be mindful that these other claims do exist.
Okay, great. So is an employer legally obliged to consider alternatives to making redundancies? Yes, they are. So if you've got an employee who has got 2 years service or more, then part of the fair process will always be for the employer to consider alternatives to redundancy. And that's at the outset of the redundancy process, but that's during the process as well. So there's a number of things that the employer should be considering. They may be disregarded, but they must consider them as alternatives to redundancy. It might be, for example, that they freeze recruitment. It might be that they reduce overtime opportunities. It might be that they don't renew contracts with contractors. If that doesn't meet all the needs of the business, then they'll move on to look at alternatives such as potential voluntary redundancies rather than compulsory redundancies, and we'll look at that in a bit more detail in a moment. They might invite employees to consider early retirement, or they might look at layoff clauses and short-time working clauses and exercise those if they are in the contracts of employment. However, whilst the furlough scheme is still running until the end of October, I would say just exercise a bit of caution on considering laying off staff or placing them on short-time working. Which leads nicely on to the next question, because somebody's asked, should an employer retain employees on furlough as an alternative to considering redundancies? Okay, yes. So the purpose of the furlough scheme, of course, was to try and prevent employers from making redundancies. Saying that, it's always been clear that redundancies can be made during the furlough period while the scheme is up and running. But the question for employment lawyers and HR professionals has always been during this time, if we make somebody redundant, and as an alternative to placing them on furlough, will we be exposing ourselves to a claim for unfair dismissal? And I think the answer has got to be yes. That is potentially up until the 1st of August, when the employer starts to having to financially contribute towards the furlough pay. So I think up until now, I think yes, if employers have made redundancies in respect of employees with 2 years service or more, instead of placing them on furlough or continuing them on furlough, then depending on the circumstances, they could be exposed to an unfair dismissal claim.
However, because the scheme is coming to an end and because of the financial contributions that are now being required from the 1st of August, I think it's less likely that unfair dismissal claims will succeed. And it's really an exercise for the employer still to weigh up the needs to make redundancies over continuing furlough. But obviously everybody accepts that their financial contribution is going to start and increase from the 1st of August.
Okay, so should voluntary redundancies be considered as an alternative to making compulsory redundancies?
It's entirely up to the business. And I think it's something, again, employers need to consider. And if they can proceed with that as an alternative to compulsory redundancies, then the advantage is that they don't have to go through the compulsory redundancy process, but it might not meet all their needs. So usually it's used when an employer needs to reduce a number of employees in a particular group or pool. So it says to the group or pool, if you would like to apply for voluntary redundancy to avoid a compulsory redundancy process, then please do so. It will do that on the basis that it can reject an application for voluntary redundancy if the needs of the business are such that they require that employee to remain in the workplace or in the workforce. So, for example, if the employer needs to retain that particular employee's skills or experience. However, be mindful that if you reject an employee's application for voluntary redundancy, there may be difficulties in the subsequent compulsory redundancy process, because when you then go down the compulsory redundancy process, you might face a situation where it becomes obvious who you're going to select and who you're not going to select, because if you've previously rejected an application for voluntary redundancy in respect of one particular employee and the group is particularly small, it might become obvious who's safe and who isn't safe. And that may prejudice then, or arguably prejudice, a fair selection process. And then also you might be faced with the situation of retaining a bit of a disgruntled employee who doesn't actually want to be there and wants to be made redundant. And they may end up resigning. You then have too few employees and you may end up then incurring the cost of a recruitment exercise. So, you know, it's a lot of, you need to go through a bit of a thought process before you decide whether it's for you to engage in a voluntary redundancy process or whether you miss that out. But as long as you've considered it, reasoned it, and thought about it, then I think that will be fine.
Great. So is an employer obliged to consider reducing employees' working hours to avoid redundancies, especially in light of the changes to the furlough scheme from the 1st of July?
Yeah, I think employers should definitely consider it, yeah. So from the 1st of July, the scheme, for today, the scheme changes. So provided employees have previously been furloughed, from the 1st of July, from today, they can be flexibly furloughed, which means that they can be brought back to work for some of their hours, normal hours of working or days of working, and they can be retained on furlough for the other part of their normal hours or days of working. In respect of their furloughed days or hours, they will be entitled, or the employee will be entitled to recover the 80% furlough pay subject to a prorated cap from the government fund. And in respect of the hours that they continue to work, then the employee will have to pay them full pay. But yes, it's definitely something that I think the employer should consider in determining whether it's appropriate and reasonable for them to enter into a redundancy process.
Great, Thanks, Keeley. So what procedure should we be following in making employees redundant to prevent successful unfair dismissal claims?
Okay, so this is when we jump to the procedure. So I'm going to go to my slides now. Right, I'm going to whiz to the procedure. So I'm hoping that everybody can see those slides. I'm hoping that they're quite detailed, so that you can use these as a basis of forming your own procedure. So step one then is the commencement of the redundancy consultation process, and I always start a redundancy consultation process with an announcement. And that may be an announcement to the whole business, or it might be an announcement to the particular affected areas of the business. So that really is down to you, and it's down to the number of, the size of the business and the number of employees involved. So what should the announcement include? Well, firstly then, it should include the details of the circumstances resulting in the potential redundancy situation. So most of our communications at this moment in time are going to be referring to the implications of the government guidance and requirements as a result of COVID-19 and the effect that has had on business income as well as level of work. We need to indicate in the announcement then what areas of the business are most affected by the situation. That might be the whole of the business, or it might be particular areas of the business. We need to confirm following that a consultation period is being entered into. And this is the beginning of the consultation process, i.e. the announcement being the beginning of that process. We need to make a statement, however, that redundancies are not definite at this moment in time. They are a possibility. And we are looking at all measures, all alternatives, all options we possibly can to avoid redundancies. We also in the announcement might want to make reference to measures that we've already taken to try and deal with the situation. That might be references to employees being placed on furlough, it might be recruitment freezes, it might be termination of contractors' contracts. So it evidences that we are trying our best to avoid having to make redundancies. We may then go on to say in the announcement what initial measures are being considered now to avoid redundancies. So, for example, voluntary redundancies or potentially agreed reduction in hours, permanent changes to contracts of employment or temporary changes to contracts of employment. And as I've touched on before, we need to make a statement that all options and possible alternatives will be considered during this process. And then we need to send a copy of this announcement to everybody. So usually this announcement is made orally, and then a copy of the announcement is distributed. In these circumstances, it might need to simply be emailed or placed on the intranet or the internal communication system of the employer. So if employees are working from home and if employees are on furlough, then we've just got to make sure that they receive this announcement in some form. So, so the announcement is the step one. We're then looking at step two, which is the communication of the measures that we're going to attempt to implement to prevent a possible compulsory redundancy process. And this might not be appropriate for every employer. So this might be missed out by some employers. And this communication usually relates to a situation where the employer thinks the situation can be dealt with by agreed reduction in hours, or alternatively, asking for volunteers for redundancy. So if we are asking for volunteers for redundancy, then we will write to our employees, indicate in the affected groups, indicate what number of employees potentially we need to reduce the group or pull by, and invite employees to apply for redundancy. We will need to indicate in that communication that we reserve the right to reject any application for voluntary redundancy on the basis of business need. So that might be because we get too many applications for voluntary redundancy and we don't need all those people to be made redundant. Or alternatively, we get applications from employees who we need to retain the skills of. But bear in mind what I said earlier about the potential pitfalls of that, or disadvantages of that. Yes, when we write to our employees asking for voluntary applications, we need to indicate in there the date and the person who they need to send their application to. We need to make it clear that the applications could be rejected. And we need to confirm that if there is an insufficient number of appropriate volunteers, compulsory redundancies will remain a possibility. We can provide our volunteers or the people we write to, our employees that we write to, with necessary reassurance that if their application is unsuccessful, then that won't in any way impact on a future compulsory redundancy process if we have to go through that, and that they can withdraw their application by a specified date if that's what we want to do. We will then receive our applications and we will need to consider them. And if we want to proceed with some of those or all of them, then we write to those employees confirming that their application has been successful and asking them to attend a meeting with us. We discuss the matter at the meeting and we confirm the decision to accept their application. And we confirm that in writing. Be aware that a successful application for voluntary redundancy amounts to a dismissal in law. So we will need to communicate, obviously, that the employee is entitled to a redundancy payment and they'll be entitled to notice. So they either work the notice or they get paid in lieu of notice. Usually, an employer will incentivise employees to apply for voluntary redundancy because it's an attempt to avoid having to go through a compulsory redundancy process. So it might be that you offer a sweetener for people to apply for voluntary redundancy if you really want to try and avoid a compulsory redundancy process. If you feel that you are exposed in any way to an unfair dismissal claim, because as I say, voluntary redundancy applications are successful, amount to a dismissal in law. So it's still a dismissal. So if the employer feels that they are still exposed to an unfair dismissal claim, then they can offer the employee a settlement agreement. And that will ensure, if they sign up to it, that they are unable to bring any claim against the employer about the termination of their employment or the facts relating to it. If an employee is required to enter into a settlement agreement, it is usual for the employer to make a contribution towards the cost of their legal fees in taking advice on the settlement agreement, which they're required to do, and that's usually to the sum of £350 plus VAT. So there is a cost that goes with a settlement agreement. One may say, well, they've applied for voluntary redundancy. How can we be exposed to an unfair dismissal claim? And that's probably true. However, if there is an exposure, and as I say, it's still a dismissal in law, then I would suggest a settlement agreement is the way forward. So moving then on to step 3, we've considered our initial options, alternatives to a compulsory redundancy process. If we don't get sufficient volunteers, we don't get any volunteers, or if we can't agree reduction in hours and we can't avoid going through a compulsory redundancy process, then the next stage is to commence that process. So the first thing we need to do is identify the relevant pool. Well, we've probably already done this, but we need to apply our minds to it properly now. So we're looking at then potentially groups or pools of employees that we need to reduce, or alternatively, there could be an employee in a pool of 1 where they don't conduct any comparable or similar work to any other employee. They hold a standalone post and therefore they sit in a pool of 1. So as I say, you can have pools or groups of employees conducting similar work that you need to reduce, or you can have potentially an employee sitting on their own doing work that nobody else can do or will do, that isn't transferable, that isn't similar to anybody else. It's difficult. It's a difficult process actually sometimes trying to determine the relevant pool. There's no fixed rules about how the pool should be defined. Usually employers will look at what work is being conducted by employees, but they might also look at transferable skills. So pools may go across departments, they might go across sections of the business, or pools might be made up of departments or units. So it's very much a factual consideration and determination of what the correct pool should be. An employer will usually want a pool to be relatively narrow. However, employees may argue it should be wider, because then of course they'll say they've got less chance of being selected from the pool. So you might have a situation where some employees are saying the pool should be wider, the employer is saying the pool should be narrower. Factors then are likely to be relevant in identifying the pool is a consideration of what type of work is ceasing or diminishing, the extent to which employees are doing similar work, the extent to which employees' jobs are interchangeable, and whether the employer genuinely applied its mind to the composition of the pool. Now, in a collective consultation process, the pool composition really should be discussed with appropriate representatives of the affected employees. Sensible starting point, as I said, is look at what the employees actually do, look at their contracts of employment, but if their contracts of employment actually don't reflect what they do, look at the factual circumstances. I think that's the starting point. What work does the employee conduct? And then you might have to look at interchangeable skills. So it becomes a bit more complicated when employees are multi-skilled or do different types of work, or can be required to do different types of work under their contracts of employment, in which case then you might need to look at these interchangeable skills as well as what the employees are actually doing on a day-to-day basis.
Keeley, can I just ask a question on this?
Yes.
Just a question in. So when considering pools, are we considering similar or comparable work, the job, or similar or comparable skills, the employee? And how much detail are we required to know about the people's skills?
Yeah, I would, as I say, the starting point for me is always what work do they do? So if they are all employed doing the work that's diminishing, that's ceasing, they will be in the pool together. It becomes a bit more difficult if there are employees from, say, one department doing one type of work, who actually drop in and out of another department, cover holidays, cover sickness, it goes to and from. And then employees in the at-risk pool could say then, well, hold on a minute, I actually do similar work to this other pool, this other group, this other department, and I've got the same skills to do that work. And actually, a year ago, I was doing that work. In which case, then the employer might then have to open up the pool to those two departments. So, I don't know, for example, administration work, you've got people sitting in an administration department, say some doing credit control and some doing payroll. I mean, that comparison isn't great because they are two different types of work, but say they're similar in terms of the skills that are required to do the job. And they do sometimes cover holiday, sickness, then you might have to look at then joining those two groups together. Does that make sense?
Yes, thank you.
So, but always start with, what are the people employed to do? Yeah, what are they doing on a day-to-day basis? So once we've got over the tricky situation of the pool, we're still looking now a pool of more than one employee, so this is a group. We now need to look at how we're going to reduce the number of employees working in that group. So this is more than a pool of one. This is a group, it might be 2, 3, 4, 5 employees in this group. We need to reduce the number of employees in the pool. How are we going to do it? Well, we do it by drafting a selection criteria and applying that selection criteria to the pool. So let's have a look at drafting the selection criteria then. You need to consider whether or not you've got any contractual redundancy criteria that should be used. That's the first thing you need to do. You need to also consider whether or not you've used certain criteria in previous rounds of redundancies, because employees might say, we used that criteria before in this round, in a round of redundancies 2 years ago, why can't we use that one? And if you've continually used the same criteria in different rounds of redundancies, then it might be arguable that you should use that same criteria again. Otherwise, if there's no risk in that regard, we need to draft criteria to reflect the present needs of the business. The criteria, of course, should be objective as possible and capable, if possible, by independent verification. So that means measurable, it would be fabulous if we could just refer to some documentation in the HR personnel file. I appreciate that's not going to always be possible, but as objective as possible and as measurable, objectively measurable as possible. So here's some potentially fair selection criteria then. So we're looking at length of service, performance and skills, experience, attendance records, timekeeping, disciplinary records, and then we're finishing off with future potential or flexibility or other. Now, of course, you don't need to use all of these. Some of them might be relevant, some of them might be not. You can add to them depending on the needs of the business. So this is just an example. The scoring is also detailed on the slide. So when you are going through the process, you will use the scoring detailed, or you can, as I say, you can change the scoring if you want to. It's an example. And then if you wanted to, you could also add weightings to reflect the importance to the business of the particular criterion. I, if possible, would steer away from weightings, only because I know some employees like them, but it can get quite complicated. So my view is try and keep it as simple as possible. And weightings can, as I say, overly complicate things sometimes. I'm not saying they shouldn't be used, but I'm just saying as simple as possible in my view. what we shouldn't be doing is we shouldn't be using purely subjective criteria, because that will be unfair potentially if we can't use objective means to measure it. So try and steer away from purely subjective criteria, and it's to ensure that we don't face an argument of prejudice, really. You know, an employee might say, the score or the manager scoring me doesn't like me, and that's why he scored me low on this criterion. So try and steer away from those subjective criteria if possible. So we've got some examples of subjective criteria that have been found by the employment tribunals to be unsuitable. The first one is employees who in the opinion of the manager concerned would keep the company viable. So very subjective. Another one, employees who are best suited to the needs of the business under new operating conditions. So again, it's down really to the manager's subjective opinion. Also cost savings as a comparison, who could cost more in terms of overheads but generate least revenue. Again, that might be able to be made more objective, but in this case it was determined to be too subjective. And then the last one that's in this case was found to be too subjective was attitude. But attitude is used in some redundancy criteria, but in this case it was held to be too subjective. And that was because it just wasn't backed up with objective factors. So although we're saying subjective criteria should be avoided if at all possible, if we can objectively measure subjective criteria, then we may use it. And in going back to that list, you'll see the end one, future potential, flexibility. Now, future potential is, you know, it could be pretty subjective. So we need to think about how we're going to measure it. And it might be that we look at training, we look at skills, and if we can back it up with measurable objective factors to reach a higher score for a particular employee, then I think that's fine. But as I say, we've got to be able to point to some objective factors if we can.
Keeley, can I interrupt you with a couple of questions? Is that okay?
Yes.
So Sue's asking, do we have to include those on probation, or can we take them out straight away?
Yeah, because they've got less than 2 years service. Yes. So if an employee's got less than 2 years service, then potentially you can do away with this procedure. Bear in mind my earlier comments of discrimination, potentially and automatically unfair reasons. So just be guarded. You know, just do you, if somebody's on probation and they've been off sick all the way through their probation, and that relates to a disability they have, then exercise some caution, because if you go straight in and dismiss them, and they say, well, you've dismissed me because of my sickness record, it's got nothing to do with the redundancy situation, you might be faced with that situation. Just bear in mind, look at the circumstances, but yes, generally you don't need to follow this this process.
Great. And another quick question along similar lines, would it be fair not to consider someone because they're too expensive to make redundant, to be made redundant, i.e., you know, if they've had 20 years service?
Yeah, again, I mean, it's bound to be a consideration at this moment in time. And I think as long as it's part and parcel of a number of criteria, then that may be satisfactory. Again, bear in mind potential discrimination on that, age particularly, because if you've got somebody who has been in your service for a number of years, they may well be a lot older than somebody who's exposed on redundancy. So they may be actually saying, if you want to retain them, you might have the younger employee who's been made redundant saying, well, actually, that's age discrimination. I think it can be justified, but just be aware of those arguments. So I think it's okay, but use it as part and parcel of a number of criteria.
Great, thank you.
We're having a look then at those, as I say, subjective criteria, caution, use objective measures. Last in. Now this used to be a really popular one, last in, first out. Same point as I made just now, I would never, and I would recommend we never use it as an only criterion. We can use it as part and parcel of a criteria, but it would be potentially age discriminatory and sex discriminatory potentially if we used it as a sole criterion in a redundancy selection exercise. And then the last point is avoid discriminatory criteria. And of course, we will all be mindful of this, but beware, it might not be blatantly obviously discriminatory. So really give some thought to what your criteria is, and run it past your HR department before maybe proceeding with it. Okay.
Where do we stand, Keeley? If a company doesn't have a redundancy policy in place, what impact does that have on the redundancy process in the business?
Nothing. In fact, it gives you free rein to determine the most reasonable and suitable process, reasonable, suitable criteria for your particular redundancy exercise. I mean, I think redundancy policies are very restrictive because actually each redundancy exercise might be because of different reasons, and you might need different criteria. So I think if you haven't got a redundancy policy and set redundancy criteria, then that's better for the business and gives you more flexibility.
Great.
Okay, so we're going to move on to the next step. We're still dealing with a pool of more than one employee. And we're now looking at consultation about the selection criteria. So we've drafted our selection criteria, we're all very happy with it, and we're now going to send it to the employees in the relevant pool and say, this is the selection criteria. We're having to unfortunately go through a compulsory redundancy exercise. I'm terribly sorry about this. This is because we didn't get enough voluntary applications, or we didn't get we may not have gone through that process, so we've considered it necessary to commence the process. And here's the selection criteria that we're looking potentially to apply into this pool to select the employees who could be at risk of redundancy. Please provide us with your comments if you would like to make them. So we've now communicated the selection criteria. Of course, if we are going through collective consultation, then the selection criteria will be discussed and agreed with unions or appropriate representatives. Step 3C then, still dealing with the pool of more than one employee. We now proceed with applying the selection criteria to the pool. So we are making our assessment now of the employees against the criteria. I would always suggest that if possible, and I appreciate in small businesses it isn't possible, that we have more than one manager involved in the scoring process. And the manager who is involved is the line manager of the employees who are potentially in the risk pool, because that person will have more knowledge than other people in the business of the particular employees. Difficult if they're also at risk. So a bit of a planning exercise may be needed. But if possible, more than one employee or manager involved in the scoring process. If we can, please use HR records so that we can back it up with documentary evidence as to why we scored in the way we did. And then we're moving on to look at potentially, looking at assessing performance. So assessing performance might be difficult. If we've got written appraisals, and we've got a good appraisal system in place, then use that, because you're going to get less you're going to get less queries and concerns potentially about using an appraisal system when employees have agreed to an assessment of their performance during that appraisal process, then obviously if you haven't got those records. If you haven't got an appraisal process in place that you can refer to in making an assessment of performance, then we're going to need to conduct some kind of assessment, independent assessment, using objective matters, factors, and scoring. And these will have to be the same in respect of each employee in the pool. So it's a tricky one if we haven't got a formal appraisal system in place. How easy it is to measure a performance is really dependent on the role. If you are reducing, say, sales employees, then it's going to be potentially easier because you're going to have already targets in place, and you're going to have data, stats on whether or not those targets have been met, and the extent of which those targets have been met by each individual employee. Different roles will have different performance assessment criteria, and they may have no criteria at all. So just be wary of that. It can be difficult assessing performance. And it's something that, you know, employees can get very guarded against, and you know, it could get difficult to have those conversations with employees about their performance scores if that's what you're going to be using as part of the selection criteria.
So should the same people be involved in scoring for members of the same team, Keeley?
Sorry, say that again, Eloise.
Should the same people be involved in the scoring for members of the same team, somebody's asked?
Yeah, I mean, that would be the best scenario. Yeah, I mean, unless they've got different line managers, of course. But I think if the same line manager is line managing 5 employees and it's the 5 employees that are sitting in the pool, then it would make sense for that manager to score all of the employees, yes. And
could, moving back slightly, could somebody use where somebody lives as a criteria? So if they had field salespeople, for example, field sales managers, could they use where somebody lives as a selection criteria?
Yeah, they could. I mean, if the assessment of the work is such that you know, you map out areas, sales areas, and the work is reducing in certain areas and not certain areas, then yeah, that's definitely a credible selection criteria process. Yes.
Great, thank you.
Okay, so then we're looking at, take care when assessing attendance. So attendance is quite an objective criterion to consider. Look at HR records, see where the attendance fluctuates, or sickness records, that kind of thing. But just be mindful. Do not take into account sickness absences if they relate to a disability, so they have to be discounted. And also, obviously, absences due to family reasons, so maternity, shared parental leave, paternity leave. So make sure all of those are discounted for the purposes of assessing attendance records. Punctuality. That's a difficult one, and flexibility, because that may impact, the scoring of those criteria may impact more detrimentally on women with childcare responsibilities. So again, you need to look at the reasons behind why employees may be more flexible than other employees, and if it is due to childcare, then you may need to consider the scoring of those criteria more carefully because of the potential discrimination claim. Tricky one, scoring. Okay, so we're going to move on then to the next step, so step 4. So we've scored our employees. We have determined who is most at risk, who's got the lowest scores. And then We've also looked at our standalone post, our pool of one. We've determined that potentially that post can be removed, and the work that that employee is conducting can be absorbed by other members of the workforce. So we then invite those employees who could be at risk of redundancy to an individual consultation meeting. So this is the first consultation meeting. We have to give them a written invite to the meeting. We should give them 3 to 4 days notice of that meeting. And we advise them that they could be at risk of redundancy. If we've gone through a scoring process, then the employee's score sheet should actually be enclosed with the invitation to the meeting. So that should all be sent then to the employee, inviting them to the meeting. So how should the meeting be held? Ideally, face-to-face meetings are the best, but in the present situation, of course, that may not be possible. So we can conduct the meetings by video link, Zoom, or another appropriate medium, whether that be FaceTime or whether that be by Skype. We can do that. Be careful we don't lose the potential formality of the meeting if we do it that way. So the invitation will still need to be sent and properly documented, the time and the date of the meeting. But it can be done. So we then hold the meeting. Now, in terms of the companion, there is no legal right for an employee to be accompanied at the meeting, but it might be good practice to give the employee the right to be accompanied by a trade union representative or a work colleague. But it's entirely up to you whether you want to offer that at this particular meeting, at this first meeting. As I say, it's good practice to do that, and I would certainly recommend it is offered in respect of the final meeting, the final consultation meeting. But as I say, it's up to you whether you want to offer it at this meeting. Saying that, if an employee has a disability, then you may want to offer that to the employee, either the right to be accompanied, and you may want to extend the companion category beyond a trade union representative or a work colleague. So just bear that in mind. So at the meeting then, the employer needs to repeat the reasons why the redundancy situation has arisen, or set out circumstances that has commenced the compulsory redundancy process. If the pool is of one employee, it will need to be confirmed that the work that employee is conducting is diminishing, and the remaining work, if applicable, can be absorbed by others. If we're looking at a pool of more than one, it is essential that at this meeting, the individual scores are discussed and they are given an opportunity to challenge those scores. So it's going to be, in a selection process, very much about the employees' scores this meeting. And after those discussions have been held, then the employer will need to confirm that the employee is at risk of redundancy. So always the question that we get asked at this stage is, should we give the employee a copy of the other employees' scores? No, you don't. You just need to indicate that they scored the lowest or the second lowest, or whatever it may be, one of the lowest, and that's why they've been selected to be at risk of redundancy. If they continue to challenge their scores, you may then want to inform them of the level at which employees were considered not at risk or at risk. So it might be that the total score of the person who just missed being at risk was this amount, and then the employee scored the next or the next or the next lowest. So you can do that, but just be wary of giving away too much, because we're going into the realms of data protection, and so if employees can be identified by reference to their scores, then we need to make sure that we get their consent before we give that information to other employees.
Right. Just another quick question, Keeley. So
yeah.
Do the collective meetings need to end before you can go into individual consultation meetings?
Not necessarily. Obviously, the collective consultation meetings will start first with the appropriate representatives. So you get the appropriate representatives in place, and then you start consulting with those representatives. And you're going to be able to filter a lot of the questions through your appropriate representatives. Once it gets to a stage where compulsory redundancies are determined necessary, then you can start your individual meeting. So yes, the two processes can run parallel, but of course the individual consultation meetings will end up being later on in the process rather than earlier on in the process. But yes, they're running pretty much parallel, but towards the end, yeah.
Thank you.
Okay, so next stage then, we're looking at the next point in the process will be, we finish that first consultation meeting and we now turn our attention really to alternatives to redundancy and suitable alternative work in particular. So one of the key points in a fair redundancy process is to ensure that an employer has considered suitable alternative work and investigated suitable alternative work. Now, there may not be any, but it still has to be investigated and it still has to be discussed. And even if there isn't any, that's no defence to an employer failing to investigate and failing to consult with an employee about it. So it's really quite important, suitable alternative work. Now, if suitable alternative work can be offered, then the law directs the timing, the form and the terms of the offer. And if suitable alternative work is offered, but it's unreasonably refused by the employee, then the employee loses a redundancy payment. So it's quite key, suitable alternative work, if it is offered, because as I say, it can avoid the employee having to be paid a redundancy payment if they unreasonably refuse it. Suitable alternative work has to be offered before the end of the previous contract, and the new employment has to start no more than 4 weeks later. So it's quite a strict time scale. And if suitable alternative work is on different terms to the previous role, previous work, then it will be subject to a 4-week trial period. And that can only be extended by agreement with the employee and for the purposes of retraining. If the trial period is successful, then there'll be no deemed dismissal and the employee will carry on in employment in the new role. But if the trial period isn't successful, then the employee will be treated as being dismissed and they will be required to be paid the redundancy payment. So suitable alternative work. So what is it? Suitable alternative work is work that is comparable to the previous work that the employee did. And it's suitable in terms of potentially pay and status and type of work, depending on the employee's skill set. If it is unreasonably refused, determining whether it's reasonably or unreasonably refused is more of a subjective analysis. So it depends on the personal circumstances of the employee. So if, say, the suitable alternative work is at a different location and the employee, because of personal reasons, is unable to get to that location, then they would be deemed to be reasonably refusing that offer of suitable alternative work. This day and age and what we're going through at the moment, it's unlikely that there's going to be suitable alternative work to be offered, but it still has to be considered and it still has to be discussed. So also as part of the exercise of determining whether or not there's any alternatives to redundancy, look at possible vacancies, and it's vacancies not only in the business, but or the location that you're making the redundancies in, but across the business as a whole, which may have different sites. So if there are available vacancies, they should be communicated to the at-risk employees, and the at-risk employees given an opportunity to apply for those. And that could be vacancies of any level. You know, don't be put off by putting forward vacancies that you think are going to be too low a status or too low a pay for the employee. Still communicate them to the employee and give them the option of whether or not they want to apply. If employees are going to apply for vacancies, obviously you need to take that into account during the redundancy consultation exercise and give them sufficient time to make the applications, go through the recruitment exercise, and depending on the outcome, finishing off the redundancy process.
So they would still need to be interviewed for the suitable alternative work?
Right, okay, so suitable alternative work is different to applying for vacancies. So suitable alternative work is if we identify work that is comparable or we think is suitable for the employee, we can simply offer it to the employee. And then it's up to them whether they accept it. If they unreasonably refuse it, then they lose a redundancy payment. Right. If there is a list of vacancies that isn't suitable alternative work, the employee can then be given the opportunity to apply for those vacancies. The tricky bit comes if there is suitable alternative work that you determine is suitable alternative work for more than one employee who's determined to be at risk. And it might be at that point you determine, how on earth am I going to determine who I offer this suitable alternative work to? In which case then you're going to have to look at objective criteria, which might be a recruitment exercise sort of thing, to determine who to make the offer of suitable alternative work to.
Great, thank you.
So step 7 then, we've got further consultation meetings if these are needed. So we've had our first consultation meeting, we've told the employee they're at risk. We've now looked at and considered, proceeded to investigate alternatives to redundancy, suitable alternative work. We then invite the employee then to a further consultation meeting. We need to make sure that those invitations are in writing. We set out the dates and times of the meetings, how the meetings will be held, i.e. in person or by video link, and offering the employee the right to be accompanied at those meetings if we want to do so. Now, the subject matter of these further consultation meetings will really depend on what's gone on before. If the employee has raised a number of issues, then you'll have to deal with those questions and those issues at this further consultation meeting. How many? It really depends on how many issues are raised by the employee, and we just need to make sure that full and proper consultation takes place. So we've had our further consultation meetings if necessary, and then we move to our final consultation meeting. So, final consultation meeting, again, we set it up in writing, just as we've done before. If no right to be accompanied at the previous consultation meetings has been offered, I do suggest that it's good practice to offer it at this final meeting. As I say, not a legal requirement, but I suggest it is good practice, particularly at this last meeting. Now, in this invitation to the last meeting, you need to indicate to the employee and warn them that a possible outcome to the process, the possible outcome to the meeting, is their dismissal by reason of redundancy. So we're drawing an end now to the consultation process, and we're advising them that it could well result in their dismissal. So they're fully aware that this is potentially the final meeting. So at the meeting then, we're discussing any outstanding matters with the employee. We're confirming, unfortunately, that we've made this, conducted this investigation. We have considered any suitable alternative work, but unfortunately none can be found and none can be offered. Obviously, if we've given them the opportunity to apply for a vacancy, we need to communicate the outcome of that. And we need to also discuss with the employee in question about whether or not they have determined any suitable alternative work or other vacancies that they might be interested in. It might or might not be appropriate at this time to have a short adjournment, depending on what the employee has said. And then at that point, we communicate our decision to the employee. So if we're proceeding now with dismissal by reason of redundancy, we confirm the employee is being dismissed by reason of redundancy. This is their notification of redundancy. And we confirm what their redundancy payment is, which is dependent on their age, their length of service, and their gross weekly pay, capped at the sum of £538 per week. And I think we're all clear on how to make a redundancy calculation. If not, obviously let me know. We also need to confirm to the employee whether they are or are not required to work out their notice period. And if the employee is on furlough, we need to indicate whether or not we want to remain them, continue them on furlough, or whether they come back and work their notice, or alternatively, whether we pay them in lieu of notice. We also need to tell them what holiday they've accrued and what they need to be paid. And then finally, we need to tell them that our decision to dismiss them by reason of redundancy is subject to appeal if they wish to do so. And we need to tell them how to appeal, usually in writing within 7 days, stating the grounds of appeal. If the employee does then appeal, we invite the employee to an appeal meeting, date, time, companion present if it's as it's good practice, and we then hold the meeting. We go through the employee's grounds of appeal with them and listen to what they say. We adjourn the meeting. We consider any investigation that we might need to make. And then we can either call them back in and have a meeting or have a remote meeting with them, or just confirm our decision in writing to them. And that is the end of the process. With regard to who holds the appeal, if possible, a person who is different to that who conducted the redundancy consultation meetings should deal with the appeal. I appreciate that may not be possible in a small business.
So Keeley, is it a statutory right to offer the right to appeal?
It is, it's good, it's really good practice. And I think that under case law provision, it's not statutory, but under case law, I think it would be held to be an unfair dismissal if an appeal process wasn't offered. Yeah.
Okay, so can employees appeal? Sorry, I'm just reading the question. Can employees appeal if a process hasn't been followed, i.e. they've not been provided with the scores or?
Yes, yeah, that would be their ground of appeal. So they would say, my ground of appeal is the process is unfair because I wasn't given my scores. And then on the appeal situation, that gives then the employer it gives the employer the opportunity to rectify that default in the procedure, because then they can say, oh, well, that's fine. There's the score sheet. You did score lowest or one of the lowest, and therefore I uphold your dismissal by reason of redundancy. So yeah, so an appeal is quite a good process for an employer because it can rectify any defects in the initial process.
Great, thank you.
And then I just want to make one point about bumping. So I get sometimes asked questions of, should I consider bumping in a fair redundancy procedure? So what is bumping? So it's a bit of a complicated scenario, but usually bumping means if, say, an employee's job role is at risk of redundancy. So their work has reduced, they're at risk of redundancy, but they actually are moved into a post held by employee B, who isn't at risk of redundancy because his job hasn't reduced, his work hasn't reduced, and they are required to bump employee B out of their job So B is made redundant, and the employee who is at risk is saved, in effect, by being given their job. So in certain situations, it would be fair and reasonable to consider bumping. And one case is where there was a senior manager, IT manager, held the job for a number of years, worked his way up through the business, and he was at risk of redundancy. He said, I should bump this junior IT person out of a job, and the Employment Tribunal agreed with him. And because the employer hadn't considered that and he had put it forward, then the tribunal determined the dismissal to be unfair. So I think employers should consider those kinds of situations, and whether or not bumping might be appropriate in certain situations. Obviously, it's case dependent and factually sensitive. Okay, so I think then we're moving on to some questions that we received.
Yeah, Keeley, we've got a few additional ones that I haven't gone through with you that people have put in the chat box. If I could just run through those, if that's okay, before we get
fine.
Pre-planned ones. And I know we're running over time, guys, so I am sorry, but I would like to try and get through things if we can for people. So, in relation to appeal, so somebody's asked, what are reasonable grounds for appeal? Can they appeal that they didn't get pay don't get pay in lieu of notice, for example?
Yeah, well, if they've got paid their notice, but yes, it can pretty much appeal anything, to be honest. I mean, saying that, this is about an appeal of the redundancy decision. So this is an appeal, them saying, I think I shouldn't have been dismissed by reason of redundancy, and these are the reasons why. So that would be a usual scenario. Not that I haven't been paid in lieu of notice. I mean, that's more of a contractual complaint. So I'm sure it could be raised as an issue and dealt with at an appeal process. But I think it's more likely to be a broader reason for appealing about the reason for the dismissal, maybe the procedure that's been adopted.
Okay, great. And Fran's asked, rather than redundancy, could we ask for a voluntary sabbatical that was unpaid?
Yeah.
Okay.
Yeah. I mean, if you can, yeah, definitely. I mean, you can be as creative as you want to be in trying to avoid redundancies, and that will be looked on favourably by the tribunal, because you're looking at ways and means of trying to avoid redundancies. Obviously, sabbaticals, you'll need to consider continuous service issues, you'll need to consider accrual of holiday, all those things that could increase the cost to the employer. But yes, consider them and discuss them with the employee by all means.
Okay, great stuff. And is the start of, going back to collective consultation, is the start of the 30 or 45 day
30 or 45.
Yeah, or consultation process, does it start from the day a company makes the announcement to the whole business or the affected employees, or does it start from the first individual consultation?
It starts when you've got the employee reps in post. So okay. Yeah, so the time starts to count when you have your meeting with the appropriate representatives. And that might be when the announcement is made, because when you make your announcement, you've probably met in a collective consultation exercise, you've probably made 2 announcements. You've done a bit of a process before the announcement I've gone through. So you're making an announcement to all employees, we're going to have to start collective consultation, and with them going through potentially an election process. Once you've got your appropriate representatives in place, that's when the timescale starts to count.
Okay. And back to the selection pool, we've got a question on that. So if you're opening up 2 departments for selection pool, and so Marie says she can completely understand that. What if some personnel in another department don't have cross-functional skills? Can your pool consist of an odd 1 or 2 people from another department?
I think that would go down to scoring assessment rather than, so I think what you'd end up doing is, if you believed that there was, say, 2 or 3 departments which conducted similar work, and there was a bit of a transfer of employees between them, then you might want to pool all 3 departments and apply a selection criteria to all 3 departments. And one of your selection criteria on that is going to be skills. And if some people have got the skills to work in all 3 areas really well, then they're obviously going to score highest, because you're going to want to retain those people, the most skilled people, to be able to do all the jobs, aren't you?
Yes, yeah, great. So another question, if you have 5 people in an office in Leicester, 5 people in Manchester, 5 in London and 5 in Wales, so 20 people's roles are at risk.
Yeah.
Is this collective consultation?
So this all comes down to, is it at one establishment? Now, so it's got to be 20 or more employees that you're proposing to dismiss at one establishment, and there's loads of case law on what is an establishment. So usually you look at, where is the administrative function? If it's a shared administrative function, then the site might have to be considered altogether. If the people are working all from different, and I know it's quite big location, you know, distance wise, but if people do move around those locations, or if there is a requirement, contractual requirement for them to move around those locations, then yes, that potentially means you have to group them together. But I would look at your main administrative, accounting, payroll function. Where does it sit? And how interactive are the sites? Are they very isolated in how they work? Okay, great stuff.
And just a question from Marie. She wants to know your thoughts on most of the employees at her company have a layoff clause in their contract. However, a small number, about 20, for historical reasons, don't. So they don't have the layoff clause. She was advised recently that she could use that as criteria in selection.
Yeah, I mean, it's objective, isn't it? But those employees, I suppose, arguably haven't been given the opportunity to sign up to a layoff clause, have they? So I mean, I think you might have to think about fairness in terms of employees saying, well, that's okay, but I was never given the opportunity to sign up to a layoff clause. If you put a layoff clause in front of me now, I'd sign up to it. So in which case then I can have the same score as Mr. Smith, who has, do you know what I mean? So I think that, yeah, I mean, it's objective, and I suppose it's reasonable in terms of the employer's ability to put people on layoff if they economically and financially need to. So that's fine. But I just think a bit further about, if the employees who have not been given the opportunity to sign up to a layoff clause wanted to, might need to think about that in terms of fairness.
Okay, great stuff, thank you. So just another question's popped up. So if you can see a clear gap in scoring, is it necessary to hold individual consultation meetings with more people than the number of roles at risk of redundancy?
No. So I would just focus in on those who you've determined to be at risk. So if you say you've got 5 employees in the pool, you need to make 2 redundancies, you do your scoring exercise, you invite the 2 with the lowest scores to the individual consultation meetings. I'd leave the 3 out. I mean, obviously, at some point you're going to have to communicate with them, but go through your process with the 2 at risk first.
Great stuff. Okay, Keeley, so if we just go back to some of the emailed in questions, because I'm conscious of time for everybody. So how should employers deal with employees on maternity leave?
Yeah, okay, so this is quite quick really. Employees on maternity leave can be made redundant. Factor in redundancy payment, factor in maternity pay, because obviously they'll be due all their maternity pay even if they're made redundant. The only thing that we really need to bear in mind with employees on maternity is they should be offered suitable alternative work or vacancies ahead of any other at-risk employees. They take priority on suitable alternative work, suitable vacancies, so they must be offered it ahead of others.
Great, thank you. And how should employers deal with employees who are certified as sick, whether this is because of COVID-19 or anything else?
Yeah, so same procedure, they're still your employees, they can still be made redundant. The difficulty, of course, with a sick employee is trying to get sufficient consultation with them for them to attend either virtual meetings or face-to-face meetings. They may say they are too ill to do that. You need to therefore potentially lengthen the process to be able to invite them to meetings when they're sufficiently well to do that. You might need to obtain medical evidence to support any assertion that they are actually fit to attend meetings, not necessarily to do work, but fit to attend virtual meetings. Think about reasonable adjustments you can make to the process to help them attend meetings. So that might be companion-wise, or it might be to deal with the process more in writing. So yes, consultation can be conducted with sick employees, but just try and make adjustments to the process to ensure the proper consultation can be conducted.
Great. And will HR and line managers who run the HR process be able to conduct their role whilst they're on furlough?
I think that's going to be difficult, yeah. I mean, you might be able to use a flexible furloughing scheme, but I would think that most HR people are already at work, and if they're not at work, they need to really be brought off furlough to conduct this kind of process, because they need to be accessible to employees. And if they're, you know, attending meetings, assisting managers on meetings, then it's going to be difficult for them to do on furlough.
Great. Can an employer claim a redundancy payment from the coronavirus job retention scheme?
No, they can't. They have to pay for the redundancy payment themselves.
Is the calculation of statutory redundancy pay affected by the fact that an employee has been on furlough?
No, it shouldn't be. So the calculation is as set out previously based on age, length of service, which of course will include the service that they've accrued during furlough, because they're still an employee. And their gross weekly pay calculated in the normal way. Now, I know some furlough calculations in terms of how the government guidance has been set differ in terms of how you would normally calculate pay. So just use your normal calculation methods, not the furlough calculation methods for calculating redundancy payment. Is capped at that gross weekly pay as well. So.
Okay, great. Can an employee remain on furlough during their notice period?
Yes, they can.
And does the coronavirus job retention scheme cover notice pay?
Yes, we've had a few questions on this. So we've got the moral obligation and then the legal one. It's all dependent on what the contract of employment says. So if the contract of employment indicates that the employer is required to give statutory notice, that's 1 week for each completed year of service, then the employee should receive full pay whilst working their notice, albeit on furlough. If the notice required to be given by the employer is at least 1 week more than the statutory minimum, then the employee can be paid just furlough pay, which might be agreed reduced furlough pay 80% for their notice period. And again, that will be recovered from the furlough fund, as will the full pay. 80% of the full pay in the first scenario can be recovered from the furlough fund. So I appreciate that morally employers may say, well, shouldn't we be paying 100% of the pay and not recover anything from the fund? Maybe, but that isn't what the law says. The law says you can recover it.
Okay. So staying on morals, ignoring the moral implication, is your opinion that an employer could pay notice pay at 80% where the notice is longer than the statutory minimum as per the ERA 96?
No. You see, in your opinion, that an employer could pay notice pay at 80%. No. Oh, it is if it's longer. So if it is at least 1 week more than the statutory minimum notice, then yes, they can be paid at the furlough fund rate. Yes, at the furlough pay rate. Yeah. And the employer does not need to top it up to 100%.
Okay, great. Thank you for that clarification. Although the government and Martin Lewis are advising at the 100%, aren't they?
Yes, I think that's what they're saying, but that isn't what the legislation says.
No, okay, great, thank you. So, Keeley, can you carry out redundancy consultations while staff are on furlough?
Yeah, you can, as I say, factor in consultation requirements. Try not to lose the element of formality that these meetings require. And I appreciate that it is more difficult doing meetings virtually, but it can be done.
Okay. Just a question from the chat box. Can an employer ask the employee to work their notice whilst on furlough? And does this need to be paid at 100% as opposed to 80%? So if they're actually working their notice?
Yeah, so if you bring furlough to an end, so you say, right, here's your notice, but we require you to work it rather than remain on furlough for it, then yeah, you're bringing that furlough to an end. So you pay them full pay, their normal pay, they work as normal, and you don't recover anything from the fund.
Right, great, thank you. And how will you carry out an effective one-to-one consultation with employees who are not physically present?
So using technology. So we're all being forced into a situation, however uncomfortable it may be for us, where virtual meetings are becoming more of the norm. So we need to make sure that our employees have access to those mediums in order to ensure that we're able to consult with them properly.
Great. So, and are there any particular discrimination risks when drafting selection criteria and selecting employees in the current circumstances?
Yeah, so I've touched upon the obvious ones. The most, I think, pertinent one, or the obvious one because of COVID-19, I think relates to childcare issues because of school closures. Because it is difficult for employees to be working their normal hours at their normal capacity and efficiency levels when they're trying to homeschool and look after children. And that inevitably is causing problems. So if you've got a selection criteria that impacts or involves an assessment that could take into account those difficult circumstances, then please bear it in mind, because that could amount to a potential sex discrimination claim. Great.
So just a couple more. Is it unfair to dismiss employees as redundant while the furlough scheme remains in operation?
So I touched on this earlier. I think you need to consider, definitely as an alternative to redundancy, continuing employees on furlough. However, I appreciate that costs are going to be increasing for employers from the 1st of August. Also, the scheme is coming to an end at the end of October. So because of those factors, I think it's more reasonable then for employers to consider redundancies.
Okay, fantastic. And final question, Keeley, thank you so much. What are the main pitfalls we need to be wary of when we're making redundancies?
Yeah, in this situation, I think the main one for me is, and we discussed it, didn't we, earlier, Eloise? I think employers shouldn't be panicked or try not to be panicked into making redundancies. You know, it is very difficult because the future's uncertain. Businesses don't know when their workload is going to increase, or increase to a necessary extent to be able to ensure that employees are working at full capacity. And they're also having to consider cutting costs to deal with the situation. But I think they need to consider continuing to use the furlough scheme against what can be a costly redundancy exercise in terms of, if you've got long-serving staff, redundancy payments, you've got notice payments to consider, and you've also got the time and the effort that the managers will be put under and have to endure during a redundancy process. So I think you need to weigh up whether or not you can continue using the furlough scheme, albeit making contributions to it, against making redundancies. And I think it's definitely worth considering that, because if you get to a situation where you've become too lean, you've made too many redundancies, and then in 4 months' time work picks up and you're going to have to then go through a costly recruitment exercise, which could have potentially been avoided. You know, I appreciate it's difficult because, you know, we all haven't got a crystal ball, but it's those kinds of considerations which I know employers are grappling with that are very difficult. Obviously, also worrying potential pitfalls are that the process becomes too informal or too slapdash because of the use of having to use virtual meetings, and we need to make sure that proper invitations are sent to employees, albeit by email, they are received, meetings are held properly, proper consultation is conducted. And then also might be difficult is assessing suitable alternative work and vacancies within a business when everybody's working remotely, because you're not able to talk to everybody, and everybody's not going to be able to feed into you vacancies, suitable alternative work in this bit of a haphazard working environment that we're all having to work in at the moment. So just make sure you explore suitable alternative work and alternatives, and that might take a bit of time because of the way everybody's working at the moment.
Mm-hmm. Great stuff. Keeley, thank you so much again. That was a great session. We've had lots of people saying thank you as they've had to
sorry to run over so much.
No, we talked about it, didn't we? It was a big topic. We've had a lot of questions that were sent in previously and then were coming in as you were talking, so I was trying to stay on top of them, but it was absolutely great. So thank you to everybody who's joined us live. I will send out the recording. Keeley's slides will be available as well. Just want to give you a reminder, so we have the HRHuddle private Facebook group that's available specifically for HR professionals, which is for networking, peer-to-peer support and learning in between the meetings that we're having. So if you're not a member already and you'd like to be, then send me a message on LinkedIn or email me to eshelton@vanillarecruitment.co.uk and I can invite you to the group. So thank you again, Keeley. Thank you everybody for joining us. Have a great afternoon, and if anybody's got any questions, feel free to come back to myself or Keeley. I'll share her contact details with you. So thank you very much, and see you all soon.
Thank you.
Bye.
Bye.
Bye.